45.
You're for the petition?
Yes.
5.
May I please, Your Lordship? With the consent from the other side, I beg to mention item number 34. As my senior Mr. S. is out of state.
34.
I further beg to mention item number 39 and 40. Adjournment slip also was also submitted.
39 and 40.
One minute. I have to. One minute. 14 minutes. By the time I will
You file it first, then make a mention.
11 minutes 10.
Last listed on 2023, my lord, that is related to disciplinary proceedings. There is a fee of
Yes, for admission, hearing,
Yes.
admission. 11th. Hearing. Let it be listed for orders first.
Yeah, please. But I think to mention item number 42, the person of the other side might not. State of taken up after
Item
42,
the
my lord.
request made by the council. Okay. Item 8.
Item 8.
Here for the petition. Any objection? Item 8.
Right.
Have you look? Right. Submitted that
Item number 36 and 37. They are tax betterment. Betterment after
36 and 37. Sorry.
other side.
1 and 2, wait. Let the matter be called up.
Objective mention for listing in NETA, last coming on 10/12/2025. The person to the enhancement of.
5th of June.
Well,
May I please? With the consent of the other side, I, on behalf of RDB, mention item number 9, madam.
Item 9 on the request made on behalf of RDC. RDB. Today you have agreed to an adjournment. What is the point in fixing a date if you agree for an adjournment? You have agreed for an adjournment. What is the point in fixing a date? If it is Vested after 2 weeks. Or what, 2 weeks? Fine. Why on Monday? Admission matter.
Fine.
Or Monday. 11.
Hello.
That the has been resolved in mediation. Then I see 91531 1538. Then the transfer party to
I pay for the accounting.
Sir Ardhor for EWD, the Sharma for accountant.
That's and see inside accommodation for today. We submitted the list, the slip also. Some person inconvenience is given.
Mr. D. Gogoi, Learned Counsel, appearing for respondent.
And
All respondent.
all. Oh, no, yes. So AG is there in the contempt matter.
127. Subject set is the personal difficulty by the parties list after 2 weeks. 21. Can have it on 20 if you want. 25th.
All right. Last one.
Yes.
Because this matter, that proposal is under process matter. His entitlement has been calculated to 21 lakhs matter till now. And my lord,
When do you want to release the amount? That's the.
we'll release my lord. My lord will kindly release this matter next week. My lord, we'll come with some concrete instructions. My lord. At the PCCF level, we have the instruction.
that the claim to the spouse is entitled to
21 lakhs, my lord, approximately.
rupees 21 lakhs for subjects that had to be deferred after 1 week. By which time you will have list on 20.
20. All right.
Five lot to.
But you have not filed the evidence?
No, not yet, Lord.
Ah.
We already been sending for vetting.
Yes, madam.
Final order, honorable court, direct to filed affidavit 27/26, Your Honor.
Twenty-seven, 426 is the order.
That is, that order is there. Madam, could not be filed, Madam. I have received that parawise comments only on what.
Pay cost. Pay cost. There is a fixed date.
It is there.
You have not prayed for recall or modification of this order. There has to be a prayer that this order needs to be
Okay.
modified.
I have not filed any application in that.
You have to pay cost. We'll grant you adjournment, but then after payment of cost.
And I will file.
By earlier order dated 2026, the learned directed by the apparently the matter is put up, Mr. Henry speed of betting department and we file within a period of 1 week. 1 week, sure.
Next Monday,
Within a
what is
period
the
of
1 week can be?
Order. 10 days time be granted. Further 1 week's time be granted. Enable you to file the evidence. File their affidavit. File. Okay.
Apply for it.
It's time. Why? Want to file? Appeal.
The next step, Malak, the degree of divorce, Malak, granted, Malak, is long, Malak.
Oh,
Thereafter, married, my Malak.
You are the first wife, second wife. First wife.
After divorce, Malak, married, Malak, my Malak. Item number 7, madam, I am seeking the compensation of family bench. He also seeking
Item number
7.
6.
6 is the madam first one, divorce one.
What is the claim here?
Compensation of family bench. The husband died, madam. The course of service, madam. On 27/1/25.
On the day of death, the divorce was granted.
Granted, madam.
On the date of death,
My lord. No, no. Right thereafter married, my lord. After divorce, my lord.
the day when the husband of the petitioner died in harness.
My lord.
On the date of death, who was the wife?
But I am my lord.
You are the wife.
My lord.
On the date of death,
My lord.
during service.
My lord. Time, my lord, yes, my lord, death, divorce of decree of divorce. For my lord, resilience by the matrimonial appeal.
Then is-
Okay, for my lord. Just okay. And this, my lord,
Ordinary appeals for the appearing for the respondent in
yeah,
item 6.
item number 6.
Private respondent in item 6.
And here is the order dated 23C, my lord. The government advocate, my lord, undertakes to case of my lord compensation of family bench. Standard process for our
The next day, the government advocate will apprise the court the steps taken to process the compassionate family pension as claimed by the petitioners in item number 6.
section 7, my lord. 7. Only 7.
Only 7.
7. Okay.
State of the appeal. Thereafter, we'll see what happens. When is it fixed? 20.
But my lord, the rule I have challenged the rule.
The rule, then it goes before the division bench. Like that. Like that. Then you withdraw the petition and file another writ petition challenging the rule. What is the question of amendment here? Only amendment of prayer is not going to help you. You are challenging the values of the rules.
The interpreting has to be declaration. The declaration.
Declaration. You may choose to do so. We are not going to advise you. You may choose to do so. But that will amount to allowing a prayer which is not proper. You have no pleadings. You only have a prayer. The only purpose, as it appears to the court, is to take these matters out of a single bench to be placed before the division bench. Can this be permitted? Indulgences given by the court should not be misused. Not that the courts are helpless. This prayer of yours will give you liberty to bench hunt. Let the appeal be heard. What is the stage of the appeal, Mr. Gauhati?
It has not been finally decided. The issue has been framed exactly on this point. That will cover.
When is the matter fixed? 20. Submitted that the writ appeal, being appeal number 37 of 26, pending before the silent yet. Five. Technically, the matter will be listed in the month of August. But you want to challenge the rules, you are at liberty to challenge it. That amendment will not help you.
When appearing for health department, just file our affidavit.
You file your affidavit. As per the mediation report, dated 25/11, mediation ended still before the court.
What they have to take. They file a affidavit in reply. Matter related to my lord. Apply for a post of constable. Has applied for a post of constable.
Yes.
Yet he was
Who are for the respondents here?
the
CGC. Mr.
SS law.
Section, you're not selected.
I was not selected. I had the written exams are qualified. The medical, I was rejected on the ground that there's an infected ward, the left ear loop.
You had?
Infected ward. And the left ear loop. And some people call it Gauhati.
Huh?
Gauhati.
Is it a ground for rejection?
No, it is not a ground, according to the.
According to the.
No, it is not a ground. According to that is the episode.
Direction note for the certificate. Password for timing, man.
Yes, Mr. Chaudhary.
Yes, madam. May I please the lordship, madam? Here the petitioner was appointed, madam, as a stricter, madam, gate employee, another director of sports here, madam. He continuously working, madam, more than 10 years, madam, in that particular department, madam. And, madam, he is neither getting minimum pay, madam, and his service was not regularized till today. To that effect, madam, I filed several reports and nothing has been done, madam, in the instant case. What happened, madam, in the instant case, madam? They filed an affidavit stating that I am not entitled for regulation of service. My lord, I have not, my lord, possessed, my lord, requisite qualification. Second, I am only working more than 10 years, my lord, and my lord, my service was not regular. I want to show one by one my lord document, my lord. First, your lord say kindly come with me, my lord.
What is your claim that you were asking for regularization
Asking for regular in terms of Jagbo judgment, my lord.
in terms of Jagbo judgment?
Yes, my lord. Jagbo judgment, I am asking for regularization, and my appointment has been validly made with the concurrence of the finance department. That
No,
document
appointment to what post?
post of sweeper,
Sweeper.
gateful post,
Great.
gateful post.
So you are appointed validly means you are appointed on temporary basis.
I am appointed temporary, but there is a my lord, some post, my lord, and I was appointed, and my appointment was made in concurrence with the finance department, my lord. I am not illegal appointment. I am a irregular.
Where is your appointment order?
Yes, my lord. Page 33, my lord. Pursuant of government letter number SWY 136 2012/18, dated 14/3/2013. The Vishal Basko, son of so and so is hereby engaged as a sweeper on wage basis as fixed pay of rupees 6,000 only period so and so with effect for so and so. The arrangement is purely temporary, may be discontinued at any time without notice. The pay may be done at this important manner. Head of the account so and so my lord. And my lord, that SYW, my lord, I have got that notification, my lord. I have filed an additional affidavit, my lord. 9 to 26. Here is number, my lord. 126. Page number 126, Annexer L, additional affidavit. In person, government letter number YW 136 to the 12th. I find my lord. SYW 136 2012/18.
This is under what? Director of Sports.
Yes, madam.
Director of Sports, is there a set of rules? Service rules?
There is no set of service for my
What is the
That
cadre?
Yes, madam. That is important, madam. Last line, madam. That letter. In regard to the post of sweeper, Director of Sports Wetlands Assam, they advised to engage sweeper on wage basis. That is why I was made my lord temporary appointment. I am, my lord, appointed, my lord, temporarily in the post. Subsequently, I am working more than 10 years, my lord, and I am.
No, but is there a post of sweeper?
That post has been created by this document, my lord. That is why I am submitting.
That is created, but doesn't have the right to be involved in that. There are some created where regular selection, etc.
Yes, my lord.
You are appointed temporarily.
Yes.
But the post where you were specifically appointed.
I was specifically appointed in that post because this letter has been mentioned in my appointment letter. I am submitting for your lordship. Annexer 30. That is why I am submitting, my lord. Now, my lord, I was that way. I was when appointed. I my lord served, and I am a national basketball player, my lord. And my lord, I was appointed only on that basis when I was appointed, although order this is not reflected. I want to submit something, my lord, India affidavit in the position. That is why my lord service has been continuously, my lord, they, my lord, engage me as a my lord sweeper in that particular department. I have annexed all the letter, my lord. Now, my lord, what is the stand of
What is your education qualification?
I am studying up to class 10. Now, my lord, as per annexer and as per additional affidavit filed by the director of sports para 6.
Page number
Page number 7.
7. Additional affidavit of
Affidavit in opposition.
Hmm.
Dated 22nd July
29 July. Prodip Timu.
Yes, ma'am. Kindly come para 6.
Para 6.
That as we get the statement made in para 7, it is answer in the state there is no government policy for regulation of service engaged in fixed pay or employee engaged on similar nature post. However, it is to mention as per finance department notification. So and so dated 27 June 2030. Service of those officers, masters and similarly placed workers were regular one-time measure who have been put in the critical condition, who have been working continuously for 10 years or when as on 10/4/2006, who have been engaged against sanctioned vacant posts, who have been requisite qualification to hold the post. My appointment is in the year of 2030. That is why they are not even giving me minimum salary, so minimum wages act and service was not. That we finally reply. Reply para 5. That as regard the statement made in paragraph 4 FLV does not admit in regard to the deponent which has the reason paragraph 5, 6, 7, 8, 9, 10, 11, etc. The statement made in paragraph 4 and 5, additional file on the deponent should submit them in a welfare state. It is impossible that an employee engaged for the same work be less than another who perform the same duty as responsible for such action and leaving the very foundation human dignity. It stated the answer in deponent that is compelled to work as a lesser ways to provide food and shelter of his family and cause self-respect. Para 16. With regard to the statement made in para 5 and 6, that is deponent does not enter in the form of the 57. It is respectfully submitted that deponent has respondent authorized issued under order number SAYW 38, whoever sought a report regarding the regularization of the service, which may be directed respondent to pass a written order. And the order of rejecting I annex minor in my additional affidavit dated 27, 20. page 7 registered file on 77/2022. Filed by them. It was filed by me. Additionally, if it is filed by me, my lord, order has been passed by my lord, Director of Sportsman. Joint Secretary, sorry, my lord. Joint Secretary, Government of Assam Sports and
Page number.
page number 72, my lord. It was filed, yes, sir. It was filed by my lord, ask my lord on 77.
The date of the order?
15/11/2022.
15.
Yes, sir.
Yes.
Refers to the letter subject and directed to on 5/7 received from itself through the content of the itself request is kindly submit a report at the end of further course of events and close the statement. Enclosure is important. Therefore, regularizing 15/11/2022. Therefore, regularizing the service of the applicant from casual grateful employee of the director of school. With reference to the letter subject cited above, I am directed to enclose herewith a petition dated 5/7/2020 received from Sri Vishal Bhaskar, casual director sport, the content of which of the sport I know there is an enclosing a report. That report is available. My humble submission before your lordship is what my understanding said. Correct. But as per Jaggu's statement, my lord,
He's not said anything. But
earlier because I argued on land pilot.
what is, where is the Jaggu's judgment?
Yes, sir.
Jaggu's judgment. Yes. Jaggu. Read from para 3.
Yes, sir. That the applicant before the court who were applicant before the tribunal notice number 5. However, the fourth applicant before the tribunal has not approached the court. Therefore, this applicant is by the applicant number 1 and 5 of the sole applicant SLPC 558024, applicant number 2 before the tribunal, whereas applicant number 1, 2, 3, and number 1, 1, where applicant number 1, 3, 5 before the tribunal. For his reference to the maintained consistency, they shall continue to be heard the original applicant number then before the tribunal. Para 4. The applicant before this court, the applicant number 1, 5, tribunal were originally engaged by the Central Water Commission on part-time ad hoc terms. Applicant was appointed as Safai Wali 1995. Well, that is important, man. Applicant, because this is the case for Safai promotion. I am also Safai. Applicant number 2 as a Safai Wali in 1998. The applicant number 3 as a Safai Wali in 1999. All three persons is responsible for cleaning and meaning and maintaining the office premises under the CWC. Applicant number 5 appointed in 2004 as Khalasi. Also decided to acting where Mali of the Khalasi was entrusted with tasks such as gardening, dusting, and other ancillary maintenance work. Throughout their engagement, this individual perform essential housekeeping and support of function. CWC establishment office is affordable, ensuring daily upkeep and contribution functioning commission administrative operation. Initially, the appointment sought for regulation of their service by finding original application, so before tribunal. They contended that over the years their role responsibility have evolved beyond the nominal level of part-time or contractual and then they were performing ongoing core function integral to the CWC operation. They relied applicable government instruction and the principle long service employee engaged against a perennial nature. Is a fair consideration for regulation provided their appointment will net not illegal and clandestine. The tribunal by its order dated 17/4/2018 dismissed the appellant fee. It concluded then appellant were not engaged on what considered regular vacancies. They had not completed what terms sufficient full-time service, such as meeting a 240 days per year criterion, and that their case did not attract the principle establishing regulation within 10 days after the dismissal. The original application of 7/4/2018, the service to all these individual were abruptly terminated on 27/10/2018 by the respondent authority without issuing any so cause notice. Agreed by the tribunal decision and subsequent conclusion, the applicant approached High Court. By the Central Administrative for a 211 title as and other directing the respondent to reinstate the was held by prior to the illegal termination of 27/4/2018, harder to regularize the service of all the people in their respective posts from the date of their initial appointment without consequential benefit. Read the mandamus or any other appropriate order or direction as the honor may deem proper and circumstances of the case. They argued High Court to recognize their long and continuous service, the nature of their work, and the lack of any backdoor or illegal entity. They highlighted that they have functioned without any break, performed tasks equivalent to regular employees. But I also, there is no break in my service, my regular employee, and has been assigned duty essential to regular upkeep, cleanliness, and maintenance of the respondent office. The High Court, after examining the tribunal decision submission advance, concluded that before the part-time worker who had not been appointed against sanction post. Here in the instant case, there is no sanction post. Nor have they perform sufficient duration of full-time service to satisfy the criteria for regularization. It relied on the principle of Secretary of State of Karnataka Unnavati holding that the petitioner could not claim a vested right be absorbed, regularized without fulfilling the requisite condition. The High Court further observed that petition did not possess the minimum education qualification ordinarily required for regular employment, and additionally noted that the employer had subsequently outsourced the relevant housekeeping and maintenance activities. Here, humanity also mentioned mine. Considering that there was no legal basis to grant the relief sought, the High Court dismissed the petition agreed by the rejection the appellant had approved by this court by way of this appeal. On the behalf of the appellant, the following argument has been advanced before us. Continuous and substantive engagement. The appellant emphasis their long uninterrupted service spanning well over a decade, and in some instances exceeding 2 decades. They argued that their duties were neither sporadic nor project-based, but permanent and integral to the duly functioning of the respondent office. Mine is well covered this point. Nature of duty. Their responsibilities such as cleaning, dusting, gardening, and other maintenance tasks were not casual or peripheral. Still, they were central to ensure clean, orderly, functional work environment, effectively aligned role associated with regular posts. Absence of performance, though their tenure the appellant will never issued any warning or advertisement against me, no advertisement, my lord. They highlighted that their work was continuous, consistently satisfactory, and there is no indication from the respondents that their performance was not satisfactory required compliance with Kumadevi guidelines. The appellant assert that their appointment were not illegal but and most illegal. Drawing on specific principles laid down Secretary of State of Karnataka by Kumadevi, they submit a long servicing employee in a irregular appointment who fulfill essential sanction function are entitled to consider for it. They may say my appointment irregular, man. That they cannot say illegal, man. Everything has been there, man. Finance department, concurrent, all things is there, man. Everything. Discrimination in regulation. The appellant point out the individual with fewer job service or similar engagement have been regularized. They contended denying them the same benefit despite of their long service. Social role continuous arbitrary difference of education and qualification. The appellant reject the respondent reliance on formal educational requirements, noting that such criteria were never enforced earlier and the nature of work does not inherently demand formal schooling. They argued that retrospectively imposing such qualification is unjustified given their proven capability for many years. In respect of educational program, this thing has been mentioned. Equity and fairness. Ultimately, the appellant submit their High Court art by focusing too rigidly on their initial terms of engagement and ignoring substantial reality their long legal service. They maintain that fairness, equity, establishment, judicial principle call for their regulation rather than abrupt termination. Appellant claim for devoid any legal entitlement that High Court was correct in dismissing their petition. Having a given careful consideration to the submission advanced and the material on record, we find that appellant long and uninterrupted service for period exceeding well beyond the 10 years cannot be brushed aside merely by labeling their initial appointment as part-time or contextual. The essence of their employment must be considered in the light of the sustained contribution, the integral nature of their work, and the fact no evidence has been the appellant thought throughout their tenure engaged in performing essential duties and to remove Central Water Commission appellant number 1, 2, 3 as a Safai Wali were responsible for maintaining hygiene, cleanliness and conductive working environment within our premises. Their duty involves sweeping, dusting, and cleaning of floors, workstations, and common area. A set of responsibilities that directly contribute to the basic operational functionality of the CWC. Appellant number 5 in the role of Thalasi with additional function akin house Mali was entrusted with critical maintenance tasks, gardening upkeep the whole outdoor premises and ensuring orderly surroundings. Despite the level part-time worker, the appellant performed these essential tasks on a daily and continuous basis for extensive period, ranging from over a decade to nearly 2 decades. Their engagement was sporadic or temporary in nature. Instead, it was recurrent, regular, akin to the responsibility associated with sanction post. Moreover, the respondent did not engage any other personnel for the task during the appellant tenure, underscoring the indispensable nature of their work. The claim by the respondent that these were not regular posts like merit, as the nature of work performed by the appellant was perennial and fundamental, the functioning of the officer, the recurring nature of this duty necessitated the classification of regular posts, irrespective how to their initial engagement were level. It is not worthy that subsequent outsourcing of this task private agency after the appellant termination demonstrate the inherent need for this service. This act of outsourcing, which effectively replaces on-set worker with another further underscores that the work in question was neither temporary or occasional. The abrupt termination of the appellant services following dismissal the original applicant before the tribunal of arbitrary devoid any justification, termination issue, without prior notice or explanation violated the fundamental principle. The settled principle of law, the event the contractual employee are entitled to a hearing before any adverse action is taken against him, but when the service sector in this case the employee has no opposite heart, nor they were provided for the decision which followed. Furthermore, the respondent conduct in issuing tender for outsourcing for the same task during the pendency of judicial proceedings, despite stay order from the tribunal, directing maintenance status quo, the lack of bona fide and the such action not only contravened judicial directive but also underscored the respondent willingness to acknowledge the applicant activity. The applicant consistent performance over the long tenure further solidifies the claim for regulation. At no point of time during the engagement did the respondent raise any issue regarding the competence and performance. In my case also, there is no minor adverse remark against the respect of his competence and performance. Their service were extended over the years, same manner, and their remuneration through the minimal was incrementally increased.
Is it still working?
I'm still working, manner. I'm regularly working in that office, manner. From 2013, I am regularly. And I'm the only one sweeper of that office, manner. I have annexed one document, another 21, she was retired from service by. But acknowledgement of the unsecured service appears to be an afterthought. As for the argument relating to the educational qualification, we find it untenable. The present context, the nature of duty, the applicant performed in dusting and gardening does not inherently mandate formal education prerequisite, but they have taken minor. I am underqualified person. It would be unjust to rely on the educational clarification criteria that will never central to their engagement or their performance of their duty for decades. Moreover, the respondents themselves have, by their conduct, shown the criteria were not strictly enforced. Other cases of regularization, the applicant long-standing satisfactory perform itself, their capability, function, making rigid system, formal education requirement, and unreasonable hurdle. In a I want to say something, my lord. Sometimes I was engaged for operating the computer also by their office, my lord. That all the document I have annexed, my lord. The applicant have also established the individual with lesser tenure or comparable role were regularized by the respondent. The council of the applicant had submitted a seniority list for employee working as multi-taxing staff published by the respondent department on 4/3/2024, wherein the following employee part of staff without required qualification. That minor education person mentioned education qualification column mentioned illiterate. I am not illiterate, I am studying up to class 10. Para 19. It is evident from that, foregoing that the applicant role were not only essential, but also indistinguishable from those of a regular employee. I am as a sweeper of the only sweeper of the office, my lord. My duty is an essential duty, my lord. The sustained contribution over extended period coupled with absence of any adverse record, one and equitable and regulation the service. Denial of this benefit followed by the arbitrary termination amount to manifest injustice. It is well established that Uma Devi does not intend to penalize the employee who will have rendered long care of service fulfilling ongoing and necessary function of the state instrument. They always take, my lord, I have argued many cases, my lord. They took Uma Devi as a seal that their service cannot.
Why did you skip the paragraph in
So,
between?
State instrument. The said judgment sought to prevent backdoor entry and illegal appointment that circumvent constitutional requirement. However, where appointment were not illegal but possibly irregular, where an employee had served continuously against the backdrop of sanctioned function for a considerable procedure, the need for a fair and human resolution become paramount. Prolonged, continuous, and unblemished service performance inherently required on a regular basis can over the time transform what was initially ad hoc or temporary in a scenario demanding their fair. A recent judgment good other as a India and others, it was held their procedural formalities cannot be regulation of service. An employee whose appointment were term temporary but has performed the same duty as performed by their regular employee over a considerable period in the capacity of a regular employee. The relevant paras of the judgment has been put to the application of the judgment in Umadidi by the High Court does not fit squarely with the facts at hand, given the specific circumstances under which the applicant were employed have continued their service. The reliance of procedural formalities at the outset cannot be used purposefully by substantive right that have accrued over a considerable period through continuous service. Their promotion was based on a specific for vacancy and a subsequent circular followed by a selection process involving written test and interview case for the appointment entry as a distance in the case of Umadidi. The judgment in this case Umadidi also distinguished irregular and illegal appointment, underscoring the importance of considering such an appointment, even if they were not strictly accordance with the prescribed rule and procedure, cannot be said to have been made illegally if they had followed the procedure regular appointment for the contact written examination. The High Court placed undue emphasis level on the appellant engagement and outsourcing decision taken their dismissal. The court must look beyond the surface level, consider relative of employment, continuous, long-term service, dispensable, its absence any malafide in their appointment. Instead, by refusing regulation simply because their original terms did not expressly state or because an outsourcing policy was immediately introduced to be contrary to the principle of fairness. The pervasive misuse of temporary employment contract as exemplified in this case reflect a broader systematic issue that adversely affects worker right and job security. In the private sector, the rise of gig economy has led to an increased precarious employment arrangement, often characterized by lack of benefit, job security, fair treatment, such as practices and exercise for exploiting workers, undermining labor standards, government institutions are entrusted with avoid of fairness, they are even better responsible to avoid such exclusive employment practices. When public sector entitled to engage in issues of temporary contact, it is only mirror and documented then observe that gig economy but also set a concerning precedent that can erode public trust in government operations. The International Labour Organization ILO, of which India is a founding member, has consistently advocated for employment stability and fair treatment of workers. The ILO multinational enterprise declaration encourages companies to provide stable employment and to observe obligations concerning employment stability and social security. Emphasis that enterprises should assume role in promoting employment security, particularly context where job discrimination and exacerbate long-term unemployment. The landmark judgment in University in Gizaginio and Microsoft Corporation serve as a pertinent example from the private sector illustrating the consequences of misclassifying employee to circumvent providing benefit. In this case, Microsoft classified certain workers as an independent contractor, thereby denying them employee benefit. The US Court of Appeal from the 9th Circuit determined that these workers were, in fact, common law employees were entitled the same benefit as a regular employee. The court noted that large corporations have increasingly adopted the practice of hiring temporary employee or independent contractor as a means of payment of employee benefits, thereby increasing their benefit. This doesn't underscore principle the nature of performance rather than the label assigned to the worker. So determine the employee status, corresponding rights and benefits, highlighted judicial role in rectifying the misclassification and ensuring that order. It is discussed concerning reality that employee, particularly the government institution, often face multifaceted form of exploitation. While foundational purpose of temporary content may have been addressed short-term or seasonal needs, they have become mechanism to create long-term obligation owed to the employee. These practices manifest in various ways. Issues of temporary level, employee engaged for the work that is essential, requiring them integral to the functioning of the institution, are often labeled temporary and contractual, even when the role of mirror those regular employees such as classification, deprive workers dignity, security, benefit. Regular employees are entitled despite performing identical tasks, arbitrary termination, temporary employees are frequently dismissed for the notice present case undermines the principle of national justice, subject worker to a state consistent security, regardless of the quality duration of their service, lack of career progression, temporary employee often themselves excluded from opportunities for skill development, promotion, incremental pay raises, they remain stagnant in their role, creating a systematic disparity between them and the regular counterpart, despite their contribution being equally significant. Using outsourcing as a seal, institution increasing so too, outsourcing role performed by the temporary employee effectively replacing by one set of exploited worker with another. This practice not only perpetuated exploitation but also demonstration effort bypass obligation to offer regular employment. Denial of basic right. Temporary employees are often denied the fundamental benefits such as pension, provident fund, health, insurance, paid leave, even when their tenure span decades. This lack of social security subject them and their family to undue hardship, especially in case of illness, retirement, or unforeseen circumstances. While the judgment Uma Devi Supra sought to curtail the practice of backdoor entry, ensure appointment adhered to constitution. Incredible that principles are often misinterpreted, misapplied to deny legitimate claim of long service employment. The judgment aimed to distinguish legal and irregular appointment. It categorically held that the employee regular appointment who were engaged in duly sanctioned posts and served continuously for more than 10 years should be considered regular as one-time measure. However, laudable intent judgment is subverted when the institution relies on the dicta where indiscriminately reject the claim of the employee. When each case where the appointment were not illegal but merely lack of adherence to the procedure for the government department often cite the judgment in Uma Devi to argue that no vested right of regulation exists for the employee, overlooking the explicit acknowledgement of the case. Whether regulation is appropriate, this selective application restored the judgment's spirit and purpose effectively weaponizing against the employee who have rendered the indispensable services of her decade. In the light of the consideration, in our opinion, it is imperative for the government department to lead the example in providing fair and sustainable employment, engaging workers on a temporary basis, extended period, especially when their roles are integral in their organization functioning, not only labor standard, but also exposes the organization to legal challenges and undermines employee morale by ensuring fair employment practice. The government can use the burden of unnecessary litigation promote job security and uphold principle of justice, fairness, they will be embodied. This approach aligned with international safeguard set of positive precedent for the private sector follow, thereby contributing overall betterment of labor practice. In view of the above discussion, the finding above, the appeal, the impugn order passed by the tribunal are set aside and the original is allowed. To the following, the submission order 27/10/2018 requires the applicants have taken back on duty of forfeit their services. They can regularize forfeit. However, the applicants have not entitled any pecuniary benefit back wages for the period they have not worked or but not entitled to continue the service for the same period and the same counted for and benefit. My case is minus clearly covered by this judgment, and Uma Devi has been distinguished in this case. Paragraph 52 of Uma Devi rather supported my case. As per I have shown my appointment letter and as per the communication between the director of schools and finance department is crystal clear that the post has been created, my lord, and I am the only Safai Karmachari of that director of school. That is my submission before your lordship, my lord. If my understand any subject, my lord, I can give the reply. My case is that.
Tell us, there is a judgment of the division bench.
Yes, ma'am.
Where it says categorically that part-time.
May I submit my lord? Your lordship has passed one judgment, my lord, where your lordship said they are entitled for regularization, and division bench said this type of employee in respect of Dharam Singh. That Jaggu judgment was not discussing that particular judgment. Only
Okay.
Dharam Singh. That division bench judgment. Or better, huh? Page 780.
Judgment is
I am coming, man. Upendas, I am coming, man. His pension about the Upendas. Upendas has said, my lord, Upendas, it was filed review for this court, and subsequently the review petition, I was appeared in the review petition. I myself appeared in the review. And my lord, subsequently, my lord, that Upendas was filed an appeal before the Honorable Apex Court. And it was hearing is completed and judgment was not delivered. Upendas never said that he is not entitled for the minimum pay scale and others. I am not on that manner. Upendas line is every case is different. Basically, it is a workers employee case, my lord. Yes, something, my lord. Workers employee case in single bench, Upendas has been, my lord, allowed that Upendas cases say you create supernumerary post and that supernumerary post, okay, you regularize the service. Then Upendas go to the minor retail by the government, minor. Government, after the argument, government that say you are entitled for medical allowance and other benefits, but you are not entitled for the pension. As per my correct position has been made to the
judgment and refer. There we have it. There are 23.
There are 22. It is, however, heartening to learn that there are 22 page number. Last my lord, was taken last paragraph. It is however heartening to learn that state government has agreed not to terminate master role worker such similarly placed overseas from time 10 years in their normal retirement, except on disciplinary ground or criminal offences. The state government also agreed enlisted health, accident and death insurance recently to the consult the state government. He appreciated the state government taken welfare management. Dialogue para 21 is lastly, the respondent Supreme Court in Nihal Singh versus State of Punjab. As Suresh and convince us that even after Umadevi, Supreme Court has directed to regular event by creating posting. The employee were not originally sanctioned post, but the different fact. Supreme Court itself has held that ratio to accidentity of Umadevi was not acceptable to them. In case of Nihal Singh, the state of Punjab special section 7 text to the law of them. The appointment of special police officer were made in accordance with the fiscally posted under the Act, but the service was not being regular on the ground of sanction court. The Supreme Court has held that in initial appointment of special judge was made legally under the statute, cannot categorize irregular, illegal appointment. Therefore, principle where not applicable. In effect, Supreme Court direct state government to absorb special act power by creating necessary order. Besides, Nihal Singh Supreme Court not dealing with the issue regulation of master role worker, workers, the employee, like the respondent in Maloti, the Supreme Court contempt merely directs authorized comply the order, regularize the employee. The High Court order for regulation admittedly affirmed by the Supreme Court must prior to the decision of Umadevi. The decision of Umadevi thus was clearly inapplicable in Malothidas in Western Arjun Moore versus State of Maharashtra also not salary copies were working. The revenue forest department, government continued 15 years or more. They could not apply regulation because neither their required examination was held by the department solicited the state government. Therefore, overcome left decided to absorb non-salary copies available vacant for subject to their making application holding required education qualification. The Supreme Court taking note the fact that non-salary copies were victim of the lapse of state government, held the ratio of the Umadevi cannot be invoked or denying them to benefit some state government to absorb them to a selection. In the case of hand, no officer holding exam respondent by selection for the purpose they could have. The state government cannot blame for any hand the decision by the respondent. It is however heartening to learn the state government has agreed not to terminate the master role workers similarly placed to work more than 10 years. Not sanction for their normal retirement except disciplinary or criminal ground. The state government has agreed as employee health, accidental death insurance should be prepared in consultation with the state cabinet. We appreciate a positive stance state government taken welfare measure of the betterment of the state. We accordingly direct to implicate the measure without further delay. Besides, we, in the light of Supreme Court Punjab versus Gauhati 2021, also direct state government to pay minimum special master role workers similarly pressure working since more than 10 years not in sanction with effect from 1 April. For this, we have viewed that the fact situation of the case master role workers are not entitled for regulation of the salary. That the appeal has been filed and judgment has been done. The judgment has been done. We filed a review application before this minor honorable signature showing that one Gujarat judgment minor. I think since after then minor then state has I think state some other master role employee filed appeal before the Supreme Court. Honorable High Court has said it appeared before the Supreme Court. It appeared before the Supreme Court and judgment has been reserved. Now I am submitting one thing. Every case is dependent upon the facts and circumstances of this. Issue another judgment. Let them show in respect of Safai Kormosari, the Jaggu case has been mentioned because it is specifically mentioned for the Safai Kormosari, not for other reasons.
Here,
Yes, ma'am.
what would be binding, not binding.
For this reason, we are viewing that tax situation, master of worker, workers worker, not entitled for regulation. My humble submission, then my lord president will come back. On the official liquidation of your lordship. Then it does not say. When my lord honorable apex court has said that the facts and circumstances in respect of Safai Kormosari, regulation can be made, my lord. In respect of Jaggu, Jaggu never discussed it.
And the fact that you have prepared an appeal before the perhaps by this argument that
It is not personal, it is rare.
then RAM. If it is RAM, then it is the judgment delivered by binding on the court and on the people. Number two, what they
I mean,
under 141 it is binding.
binding,
Now the question is, does it entitle this court to overrule? When does, in view of
yes, my lord, because Jaggu specific, my lord, specific,
was the law? That is,
I have to go, my lord. The better, my lord, can be, my lord.
the other alternative is that you have already prepared an appeal, the matter has been heard. Judgment prepared.
When
When
that's
does?
one.
When does? Let us say,
In fairness, I am not the party, man. This petitioner is not the party.
may not be, but let us say
Please reverse, my lord, because same type of judgment, my lord, the open dash type of judgment, all
You are-
judgment were reserved by the same
you are
judgment. I should not
entitled-
mention this.
you are entitled to focus. You know,
No, my lord. I am what
But-
I am submitting, my lord.
but
I can
supposing,
produce-
supposing judgment reverse, then when does it no longer be a hurdle?
Yes, my lord. I submit before your lordship from the, my lord, judgment passed by that particular court in respect of workers and employees. No? Other employees.
Which one?
For that particular elsewhere, I should not mention. The lordship can, it is my lordship adjourn the matter for some time.
That is the first thing you should have said
Yes, ma'am.
instead of taking us to their judgment.
But I am entitled for minimum scale, that also not given. With the
But
same
if you are entitled, then you are abandoning your aim for reference.
moment. I am better adjourn the matter.
Then Mr. Nayak, what is the conclusion in Gopaldas case?
That is the very recent judgment. And that has been appealed by the division. I mean, not interfered by the division. If Lordship allows me, I will only take 3-4 minutes by showing this judgment note. If Lordship is not satisfied, then I will argue whatever my learned friend has submitted.
No, no, please, category.
Not categorical. Even Jaggu's judgment, Lordship, two specific paragraphs, paragraph 20 and paragraph 26. Lordship will read carefully. It has never, I mean, distinguished or diluted
Paragraph
20 and 26. Paragraph 20 and 26. Paragraph 20. Lordship will, I'm reading slowly, Lord. Paragraph 20. It is well established that the decision in Umadevi does not intend to penalize employees who have rendered long years of service fulfilling ongoing and necessary functions of the state or its instrumental. The said judgment sought to prevent backdoor entries and illegal appointments that circumvent constitutional requirements. However, where appointments were not illegal but possibly irregular, and where employees had served continuously against the backdrop of sanctioned functions for a considerable period, the need for a fair and human resolution becomes paramount.
prolonged, continuous, and unblemished service performing tasks inherently required on a regular basis can over the time transform what was initially ad hoc or temporary scenario demanding fair regularity. In Binod Kumar, thereafter Lordship, it was considered. If in the Binod Kumar portion, Lordship comes 7, one small Roman, I mean, italic 7. Lordship has seen in the recent judgment of this court in Binod Kumar and others, etc. Binod Kumar has been quoted in the bottom later portion of it. In the Binod Kumar, Lordship may kindly see the paragraph 7. The judgment in the case Uma Devi also distinguished between irregular and illegal appointment, underscoring the importance of considering certain appointments, even if were not made strictly in accordance with the prescribed rules and procedure, cannot be said to have been made illegally if they had followed the procedure of regular appointment, such as conduct of written examination or interview, as in the present case. So far as that case was concerned, interview was there. And lastly, if Lordship comes to paragraph 26. Paragraph 26. While the judgment in Uma Devi sought to curtail the practice of backdoor entries and ensure appointment adhered to constitutional principles, it is regrettable that its principles are often misinterpreted or misapplied to deny legitimate claims of long-serving employees. This judgment aimed to distinguish between illegal and irregular appointments. It categorically held that employees in irregular appointments who were engaged in duly sanctioned posts and had served continuously for more than 10 years should be considered for regularization as one-time measure. However, the laudable intent of the judgment is being subverted when institutions rely on its dicta to indiscriminately reject the claims of employees, even in cases where their appointments are not illegal. So, where is the dilution of, where is the distinguishment? But merely lack of adherence to procedural formality. Government department often cites the judgment in Uma Devi to argue that no vested right to regularization exists for temporary employees, overlooking the judgment explicit acknowledgement of cases where regularization is appropriate. This selective application distort the judgment spirit and purpose, effectively weaponizing it against employees who have rendered indispensable service over decades. So far as the principle laid down in Uma Devi judgment, that has been, cannot be said that Jammu has distinguished or diluted that judgment. One judgment, Lordship, I would like to.
Jammu has diluted what?
My friend is saying that Uma Devi has. But the principles still lie.
The court has said that it is on a different
Yes, Paro. I never said
different area, different sphere.
Court say, Uma Devi says, laid down the
Uma Devi
principle.
distinguishes between regular, irregular,
Yes.
illegal,
Illegal
and irregular.
That distinction between illegal and irregular still remains. Lordship, one judgment in one judgment, Lordship. For 3 lines, Lordship, I would like to probably that judgment is not before your Lordship.
But what is the status of the matter? Think this matter.
There will be wait, Lordship, till the judgment comes.
every number is available.
Has,
Otherwise, Lordship, I have a different outlook.
If I take double.
Yes, where is Mr. Roy? Getting from 10:30.
One more yes, file, my lord. This is not complete. The copy which has been served to us.
File a correct copy of the affidavit. There is no difference.
Court file is fine, but in our file, around
You
100,
have already filed your rejoinder.
I have also filed, my lord.
Then how can you file it on a half?
No, the annex has been annex has.
You already filed your
Yes,
rejoinder.
that is true.
File your rejoinder. Apply it on record.
Yes, that is.
Now you
Otherwise,
will
I can do. Yeah.
Huh?
Based on the materials that are there, my lord, I can do.
That's the argument.
I was rejected. My lord, the examination was for the post of constable, my lord. After that, my lord,
Where is the DM?
gave me the issues of first order, my lord, is at page 58. The DME. My lord, inspected ward at left earlobe. Then on 27/11/2025, I appeared before the review board, my lord. Before that, my lord, after 25th, my lord, I was sent to the private hospitals, my lord, at page 61, my lord, may kindly see page 61. I was taken by the authorities concerned, my lord, at Hyatt Hospital.
First the detailed medical examination.
Page 58.
Infected ward.
Infected ward and left earlobe.
Then after that you are taken to higher.
Hyatt.
Or is it for review?
Thereafter review.
Review.
Review was on 27/11.
Same day.
No, this is on 24th was the DME. The
23rd.
report came out on 25th. Then, my lord, we were taken to the Hyatt Hospital.
No, review is on 29.
The report is on 29. 60. 59 is the type code. And before that, I was taken to the first to the Hyatt Hospital, the ENT specialist. Then the ENT specialist had referred the petitioner to the dermatologist, and the dermatologist opined that I am fit for job, my lord, at page 63 at Apollo Clinic.
For what? What?
Because on
Of course
top right side,
Of course, you're fit for job, but what job?
job for which I have applied for the constable.
Where is the indication in the report?
And my lord may kindly see page 60
You said it was higher,
that I have made a statement, my lord.
but it seems
From
it appears to
Apollo
be
Clinic.
Apollo
61, my lord may kindly see.
61.
61.
This is from Higher Hospital.
But they have referred for dermatology.
Dermatologist at page 63. This is Apollo Clinic.
So Apollo said that what is that we can't read it. There's some medicine prescribed.
Down below this is fit for job.
But medicine also prescribed for that dermatologist.
So fit for what job? There has to be specification. You're not applying for any job.
My lord, I was taken by them, my lord. I have made a categorical statement, my lord, in paragraph 11, my lord.
Where is that regulation for rejection?
Regulation, my lord, page 99 may kindly be seen, my lord. One which they are relying upon. These are the general grounds of rejection, my lord. And infected ward doesn't fall within this criteria.
Confirm that the diagnosis of the DME can have antibiotics for the infected. The page 68 of the Proceedings, paragraph 2.6. Here before the review. The review medical exam. The required examination for going to take the opinion of dermatologist, their opinion here low, skin work on stage. Examination confirm the diagnosis of the DME and prescribe antibiotics for the effective.
Is there anything that infection, any part of the body, yet infectious wound or anything? Why do they need that?
Because lots of experts
Because your
page
your
60.
DME has infected part. Then RME and RME.
RME page 60. Opinion that due to infected bone. Infected bone present in the left. That treatment cannot be.
Page number.
Tag copy 59. My opinion.
Infected bone present. The outcome of the treatment cannot be predicted. Hence, not.
There is no category finding by the RME that inspection was a problem. Recurring infection, then
That
yes,
was not there.
that opinion is not there. So he says that he will prescribe some medicine. Whether he says condition has improved from that there is a requirement that person brain infection. But it's not seen in correct one government department and get an opinion. Then decide. Have any opinion. Find out and give it. Here, just directing him to file. There's no file an application. He'll appear with RME. Medical. And medical required by presenting him. Then pass a note whether that action is not determined.
The standard case. The written case.
Part, the weird part. Here, in was sent by the department.
Yes.
Higher office. where they would advise to take it up. Dermatologist. Medical finding final opinion that he was considered unfit, infected. That is the outcome of treatment. File any representation. Raised uniform guidelines.
125 because we have rejected this the ground of page 125. Such type of fungus infection which is existing.
One.
125.7.
Guideline. So, question specific.
time, my lord, one book. Necessary. Here the medical, but there was an interim order, my lord. Yes, there was an interim order on 7/1/2024. 7/1.
7/1. Remain in force.
Right.
Numbers if you have.
Lordship, I
The matter is fixed on 19/5. April, Lordship.
19/5.
Lordship. WPC
They
605.
submitted that section aspect of editorial jurisdiction. Right.
52 of the
And not necessary, both are disconnected.
Right.
19/5. Mr. Borwa, 19/5?
I
Correct.
also
That today it is serving copy of promotional executive.
Time of her appointment, my lord, the she declared that this was pending against her, my lord. Definitely, my lord. Disclosure of her, my lord. And, time, my lord, 11 point of time, one affair was which was under this ministry. So now
What have you stated in the affidavit? There is no pending criminal case.
because the affair was at the stage of, my lord, investigation. And that is already cleared, clarified by the Honorable Supreme Court. It is Janagiraman case, my lord.
That is on a different footing.
Yes.
That is then putting under seal cover.
And I see, but matlab, the
How do
question
you
was,
say that there is no criminal case pending? It
No,
does
madam.
not say criminal case before the court.
lodging of FIR.
Closing of FIR.
That is, that I have to disclose whether FIR that is not the case. I have to disclose whether any case, criminal case is pending.
Can't give a very,
Yes.
very restricted technical meaning of criminal case.
Because that was the question come for consideration.
If you apply for bail,
Yes,
you apply for bail,
yes,
filing the FIR.
yes.
Then
Now,
why did you apply for bail? If it is not a criminal case.
this is FIR against the FIR at the time of investigation.
That's right. So therefore, it is a matter where you apprehended arrest. Therefore, apply bail.
Now, my lord,
So how do you say that this is not a criminal case? It is not merit.
and now, my lord, so for is concerned, the search, not even my lord, search was not even my lord, already been decided. So therefore, such cases where non-disclosure of a particular case wherein case is not pending, and acquittal or discharge, my lord, such cases, and lenient should be taken by the this is the my lord, otherwise the judgments of the court also, the Honorable Supreme Court. So on this context, my respondent counsel, let me inform, my lord, that to my lord may take up. That to my lord.
Purpose of circulating the post list is that they are expected to know
But,
who's there, who's appearing.
earlier,
Mr. Surya, you are there. Your name is very much glaringly available.
Yes,
in the order sheet.
yes, yes. Yes, yes. But at the time of the police verification, there all I police should furnish the affidavit. In the affidavit, there is a column whether any pending case is pending, any criminal case is pending or not. In this column, my lord, he has my lord denied it, said no. That's why my lord actually found that one FIR was filed against her, my lord, and before that, for application filed for the post. That's why my lord, the proceeding was drawn against her, and accordingly, my lord, this is drawn against her. That is the case only. That is the admitted fact, my lord. The affidavit has already shown lots of penalty in the affidavit.
But according to the pending FIR,
No, the FIR, my lord, the charge sheet is filed. Charge sheet is filed.
on the date when affidavit was filed.
Oh, that is her one of false statement. That is her false statement. Actually, in the Dibrugarh PS case, my lord, charge sheet was filed against them.
On which day?
1/11/2020. My lord, charge sheet is on 21/7/2023, my lord. And lawsuit that will find, my lord, at page 37 in the third paragraph, my lord, in the so cause. Yes,
Third paragraph.
yes, my lord. Third line, my lord, charge sheet number 70/2020, dated 21/7/2023.
2023.
Yes, ma'am.
So
And-
the affidavit was filed on 17th of May 22.
My lord,
Yeah.
That's what. File. One 11/2022. 1/11,
Which affidavit? Page number?
page 35.
111.
Yes,
Yes.
11
22.
36.
No,
Sir,
but
is
you,
of after
you sign it as 17th day of May on the second page. Then Gulaghat.
I'm
Which is the
sorry.
correct date?
Yes, at 17 is the correct.
Then you say 111.
prior to my lord, Sarsit is the 21/7.
Yes, decision to file an appeal.
I filed the appeal, my lord, and they were that in the second so called that without serving the one report. Then, my lord, already they have
So
come to a
why was the first show cause issue?
first of all, my lord, asking the ground with the allegation to proceed with my lord, the inquiry, department inquiry, case 30. With the statement of the same thing, my lord. At that time, my lord, case 30. First of all.
Then why showing second show cause?
After second show cause, after the inquiry report, they should forward the inquiry report along with the second show cause notice. This is in fact after 1975, the 42nd amendment, that PCIL judgment is there. It's very clear, categorical, that you the delinquent or the employee should not be suffer or given opportunity in all stages to provide a copy of the inquiry report along with the second supervisor. But they have not provided that, my lord. And I am prejudiced because I could not also, my lord, I have taken them down, not procedure, when they have not given the scope me to process the witnesses. And in fact, in the second supervisor notice, what they have directly written, why punishment shall not be given? Page 37 is the second supervisor, page 38, last line can be seen. They have already come to a conclusion that we will impose to measure penalty. Page 38, my lord. Hence, you are directed.
Then you submitted your reply
I submitted my reply, but
without raising the objection that the copy of the charge sheet is not available.
correct.
Inquiry report.
But the mandate of the law, my lord, they should follow the
Provided the prejudices from the reply shown here to have prejudiced you. That extent.
At that point of time, she was on the ground that bona fidely, because this was at the stage of investigation, until and unless I am proved as guilty, therefore, non-disclosure may not be a ground for dismissal. So that was, she was harping in her reply. But however, page 38, and this even last line, hence, you are directed to submit your reply in seconds of
also filed an appeal. Did you see the copy before filing the appeal?
Yes, not.
At the time, filed an appeal. Sorry. See the copy of the inquiry report. Filed an appeal.
Here it has taken the ground, my lord, that inquiry report has not been given and scope for prosecution has not been afforded. These grounds he has taken, my lord. Madam, it's okay.
But the report is available here.
Yes. The report for the referendum. One, my lord. One, my lord, directly.
Perhaps not disputed that you did not serve the inquiry report.
That the person who has terminated is not the appointing authority, thereby he does not have competence to issue the punishment order. So my appointment by the assistant inspector general and the punishment order has been issued by the commander, my lord, wherein I was one of the posted. He is the disciplinary authority without the approval, in fact, my lord, from the appointing authority. Appointing of case 25, my lord, my appointing of the assistant inspector general. So, on that view also, my lord, this termination order.
Lord, in this matter, we are challenging an order of dismissal passed by the disciplinary authority. But my lord, before even going to that stage, only on a short point, lordships can interfere in this matter. Now, if your lordships would kindly come to page number 40, 440, my lord. This is the show cause notice. You are hereby asked to show cause under Rule 9 of the Assam Services Discipline and Appeal. Read with Article 311 of the Constitution of India as to why any of the penalties prescribed in Rule 7 of the aforesaid rule shall not be imposed on the following charges based on statement of allegation attached herein. That on 24/10/18, while you were posted as Lakmatlal Dispur Revenue Circle, Gauhati Metropolitan District, you were arrested by Vigilance and Anti-Corruption. Some upon being caught red-handed while accepting a bribe of rupees 40,000 for issuance of a sale permission for land from Pansumi to file FIR against for alleged demand of 1.5 lakhs. Therefore, you were charged with offence of lack of integrity and honesty. That upon your arrest on 24/9/2018, 24/10/2018, were remanded to police custody for 4 days. Thereafter, which was well beyond 48 hours of detention, thereby leading to detention. We were therefore charged with offence of causing embarrassment to the government, tarnishing the image of administration, and affecting the reputation of the government. So, with greatest of respect, my lord, these are no charges. Merely because somebody is arrested in a criminal case, that by itself cannot be a charge. Because that criminal charge has to, my lord, ultimately withstand the criminal trial, and there has to be an order of acquittal. In any case, my lord, I submitted my reply at page 41. Then
There's
nothing. No statement of allegation, no list of document, nothing. But if my learned friend can produce from records, I don't know. To our knowledge, there is nothing. I'm reading the reply, my lord. At the inception, accept my good wishes. I hope and believe that after receiving my reply, you are self satisfied that no case for department against me. That, sir, I have received the show cause notice. Also, it is a single page show cause notice. No document whatsoever has been furnished to me. See, this is the basis of the instant show cause notice. That being highly prejudiced without document, but having been asked to submit reply to the show cause, I am sending the instant reply to your good self, which is a matter of record. That, sir, I have been in service for decades, and till the date, that is 2014-18, no whisper of allegation has been made against me from any quarter. This is a matter of record. That on 2014-18, I was arrested on the basis of a false case. During arrest, I was charged physically and nothing was recovered from me. That the case on the basis of which I have been arrested is a trap case, which according to the informant offered me money, and I have put the same in my pocket with presence of shadow witnesses and police officers. That, sir, 2014-18 was an auspicious day and Lakshmi Puja and was celebrated in our office. Immediately the police officers searched my body and nothing was recovered from it. Lordship knows in a case of trap, especially section 7 of the PC Act, two conditions must coexist. That proof of bill of bribe giving and bribe taking. Nothing was proved. Anyway, that is on the criminal side. In the criminal case, till that, my lord, no charge sheet has been filed to the best of our knowledge. Then, my lord, an inquiry report was submitted at page 49. One page. Interuddin Ahmed Latmondol appeared for the hearing of so and so, stated the following as accused himself was caught by uninformed police from Vigilance and Anti-Corruption in the office hour. Mr. Hafizul Ali, driver of accused Latmondol, handed over on the same date to the Vigilance and Anti-Corruption. Peruse the report submitted by investigating officer, Inspector of Police, Vigilance and Anti-Corruption Unit's chemical reaction of the solution stated. On observing the fact, it is found that Interuddin Ahmed was found guilty on the ground of misconduct, which caused embarrassment to the government and him in the public service. Therefore, as per Rule 3.10.2 of the Manual of Departmental Proceedings, Graduate Rule 7 of the Assam Services and Rule 25 of the Assam Services Pension Rule, the accused Interuddin Ahmed is penalized with compulsory retirement. For his offence, the amount of pension will be as per rules. Not inquiry report is punishing me, my lord. There is no finding the whether I am guilty or not.
the inquiry.
This is the inquiry. Now, most interesting part is, now, my lord, there is another inquiry. Page 61, my lord. Consequent upon transfer of the former inquiry officer of DP drawn up in respect of Soil Interuddin Ahmed, land record assistant, Biswajit Soike ACS, additional district commissioner, Kamrup Metro, is hereby appointed as inquiry officer for completion of the departmental proceeding. He is directed to conclude the departmental proceeding within 30 days. Now, my lord, the second inquiry officer is appointed. Now the report is at 63. In inviting reference to the subject cited above, I have the honor to submit herewith the report on the inquiry conducted by undersigned as per section 9(7) of the Assam Services Disciplinary Bill upon the charges framed against Syed Interuddin Ahmed of School Revenue Circle on the record the undersigned. Charge number 1, violation of section 13 of the Prevention of Corruption Act as enacted. I do not know when the charge memo was given to me. Charge number 2, causing embarrassment to the government, tarnishing the image of the administration, affecting the reputation of the government. If in the criminal case, the charge is established, then the charge may be correct. Otherwise, not. In this regard, it is mentioned that inquiry officer Jharnajyoti Patpiri SCS ADC Metrodata has already submitted the report on 31/8/23, wherein the delinquent official was found guilty as charged. That's the first report. The copy of the inquiry report was served upon the delinquent official on so and so, by later dated so and so. However, on 18/6/24, delinquent official has raised objection to the inquiry report on the following grounds. He was not furnished with documents on the basis of which show cause notice was served. He was not furnished the documents on the basis of which inquiry was conducted. He claimed that no substantial proof was found of his involvement in the accepting bribe. He was not furnished with police report on the basis of which inquiry was conducted. He claims that the inquiry officer did not examine witnesses and he was not given opportunity to cross-examine witnesses. He was not informed of the charges made against him. On 8/7/24, while later, he was served once again with all the documents he claims on the receipt and on non-receipt, and he has submitted reply on 18/7. However, he has not submitted any new evidence or witness to prove anything contrary to the report submitted by the inquiry officer. Charge sheet has already been submitted by inquiry officer so and so. Presenting officer in his report has also presented that delinquent official could not produce dismissal of charges against this. So, my lord, it is not the duty of the charged officer to disprove. It is the duty of the presenting officer to prove the charges. In view of the above, after careful examination of documents presented, nothing contrary was found against the report submitted by inquiry officer dated so and so, and the charge framed against the delinquent officer is confirmed, and action may be initiated accordingly. But sum and substance is, first inquiry report is reiterated by second inquiry officer. Now, this is the first time in my 40 years of practice I have found such a course of action. Now, most importantly, my lord, now thereafter I have been given the punishment of.
This is what?
This is the inquiry report, second inquiry report.
Again.
So, what he is doing, my lord, he is reiterating the first inquiry report. And first inquiry report I have already disclosed, my lord, nothing has been done. In fact, my lord, there are no charges. Merely because I was arrested in a criminal case, that by itself cannot be a charge. That by itself would be a charge only when I am proved guilty. Then, my lord, that finally at page 66, the order, my lord, impugn order. Whereas the departmental proceeding by DP was initiated against Syed Interuddin Ahmed, office of the so and so, and whereas Syed Interuddin Ahmed Eastern was given opportunity to show cause, and whereas show cause reply was not found satisfactory and inquiry officer and also presenting officer were appointed. Peruse the report of the inquiry officer, which report, and it has been found that all documents attached with report are substantial for finding of the inquiry. And whereas report of the inquiry was served upon Syed Interuddin Ahmed, and he was given opportunity to give explanation on the inquiry so conducted. Whereas reply filed by the Syed Interuddin Ahmed land record assistant was perused, and it was observed that reply did not bring in any new facts in support of his denial, and all the aspects had been well covered by inquiry report which proved the charges. And whereas the undersigned, after careful examination of the report, satisfied with the findings of the inquiry officer, and the matter relates to misuse of official position, causing harassment to the citizen, and is deplorable in any society comes to the conclusion that Syed Interuti Ahmed, office of this so is unfit for continuing employment of. Now, therefore, in pursuance of 77 of the Assam Services Discipline Appeal Law, read with provisions of Article 311 of the Constitution, I, Sumit Satwan, IAS District Commissioner and Authority, do hereby impose penalty of dismissal in respect of as Interuddin Ahmed, Land Record Assistant of NFA. So, my lord, this is how I was punished. Then, my lord, I filed an yes. Penalty of disposal. Dismissing. Now, my lord, kindly come to their affidavit. There's a very short point involved, as I say. Please take page 72, my lord. Part of the affidavit. Then thereafter, page 72, the inquiry officer, while proceeding with the said departmental inquiry, had made several attempts to call the complainant's relative for hearing, but the individual could not be found in a given address. However, Afizul Ali, the driver of the petitioner, was heard in person and writing. Further, not being satisfied with the inquiry report submitted by Srimati Jhanajyoti Pankiri, the then ADC and inquiry officer of the said DP, District Commissioner being disciplinary authority, had appointed a new inquiry officer for completion of it. This is where, my lord, an informative which goes to the root of the matter has been
Satisfied.
Cannot.
They did not disagree with the finding.
Eventually, my lord, the first inquiry report was reliable. So, my lord, this is a end of the day, my lord. Your lordship is examining the decision-making process. I admit, my lord, there was a charge that I demanded bribe for giving a report in respect of a sale permission. For it, the allegation is I demanded some money, some amount of money was paid. That is how, my lord. And end of the day, my lord, that complainant was never examined because he didn't turn up. Now, my lord, the issue is lordship is examining the decision-making process. Now, what is the decision-making process? Rule 9. Rule 9 of the rules. Rule 9 clearly delineates how charges will be framed, how witnesses will be examined, how inquiry officer will conduct himself, and how eventually pass an order. Now, here in this case, an inquiry officer was appointed. I have already read both the inquiry officer. In both the inquiry reports, both of them has not came to any finding that I am guilty of the charge. But the disciplinary authority, the deputy commissioner says he is satisfied with the findings record. What is the finding? There is no finding. Now, my lord, the question is the procedure adopted. Now, can a disciplinary authority say that there is an inquiry report? I am not satisfied, therefore I am appointing another inquiry. That vitiates the whole proceedings. Also, I will place two judgments on this point. Yes. Yes, it. First judgment I am relying on in Millard.
Dear Dave.
Yes. Please come to paragraph 12, 13. Here, my lord, rule 15, which is perimeteria to rule 9 of our rule, was interpreted.
With regard to Dinu.
Yes. It seems to us that rule 15 on the face of it really provides for a one inquiry, but it may be possible if in a particular case there has been no proper inquiry because some serious defect has crept into the inquiry or some important witnesses were not available at the time of inquiry or were not examined for some other reason, the disciplinary authority may ask the inquiry officer to record further evidence. But there is no provision in Rule 15 for completely setting aside the previous inquiry on the ground that the report of the inquiry officer does not appeal to the disciplinary authority. Disciplinary authority has enough power to reconsider the evidence itself and come to its own conclusion under Rule 9. So, my lord, assuming for example, in this present case, my lord, the disciplinary authority having found that first inquiry officer has not conducted the inquiry properly, he could have directed a further inquiry by the same inquiry officer, saying, these are these allegations, give him all the documents, therefore you conduct a fresh hearing. But that was not done. So to say that disciplinary authority is empowered to appoint a second inquiry officer, that in my humble submission is not correct. Then the Lord will kindly come to the other judgment, para 24 to 28, Vijay Shankar Pandey. This is a judgment which has been authored by our former Chief Justice, Justice Shalameshu. Paragraph 24, Lordships will, para 25, Lordships will find this particular para which I read is quoted. So I'll not trouble your Lordships with that. Please come to page 603 on the top. In our view, rules do not contemplate an action such as was taken by collector on 13/2/16. This is from the KRDIP. I'm reading it, Miller. Then I'll read 26 and 27. It seems to us that the collector, instead of taking responsibility himself, was determined to get some of the officer to report against the appellant. The procedure adopted was not only warranted by the rule, but was harassing the appellant and allowed the appeal of KRDIP. Now, this is important. It can be seen from the above, the normal rule is that there can be only one inquiry. This court has also recognized the possibility of a further inquiry in certain circumstances enumerated therein. The decision, however, makes it clear the fact that the report submitted by the inquiry authority is not acceptable to the disciplinary authority. It is not a ground for completely setting aside the inquiry report and ordering a second inquiry. So I am on this now. Now here is a case where the disciplinary authority says, I have changed the inquiry officer because it does not appeal to me. So that is not the consideration. Therefore, in my humble submission, it is a case where Lordships will interfere, and maybe Lordship may demand, may not demand from the stage where they may not, they will give an opportunity. There is no question of sustaining this order. Now, may not kindly come to the disciplinary authority's action. Now, disciplinary authority says, now please come to that disciplinary authority's order once again. 66. Page 66, last two sentence. And whereas the undersigned, after careful examination of the report, satisfied with the findings of the inquiry officer that matter relates to misuse of official position causing harassment. Which is that finding? There is no finding in both the reports. Some observations. First of all, my lord, it is not a charge sheet. Merely because a criminal case is pending against somebody, that by itself cannot constitute a charge. This is the meaning of Rule 7. Now, therefore, my lord, therefore, my humble submission is the fact that the second inquiry officer was appointed and he exactly what was not supposed to be done, my lord, he relied upon the first inquiry report. Therefore, my lord, it's a comedy of errors has crept in this case. So, Lordship, my humble submission is, Lordship will set aside the order of penalty, set aside the inquiry report, and Lordship may say that disciplinary authority may appoint an inquiry officer from that stage by the same inquiry officer. That's a different aspect. But as it stands, my lord, it cannot. This. And kindly see, my lord, end of the day, when we say that the procedure adopted is not fair, all that we say is the due procedural safeguards provided in the rule has not been provided to me. Let them show from the record that I was given an opportunity of cross-examination. Let them show from the record that documents were given to me. Let them show from the record that list of witnesses were there. And let them file the charge sheet in the criminal case, wherefrom it will appear that the charge of giving and taking is proof or prima facie established. So if the allegation of nothing was recovered from me, therefore, my lord, the trap failed. Once trap failed, my lord, in a case of in a criminal case, my lord, nothing will happen. You will get an acquittal. That's why till that they have not filed the charge sheet. And my lord, the complainant was not present. Then on whose version, my lord, they found it to be a correct version? It's a presumption of innocence until I am proved guilty. Well, merely because that is why it is said, my lord, when same set of facts are taken in criminal case and departmental proceeding, departmental proceedings await the outcome of the criminal case. That is why Supreme Court has said that, my lord. Exactly on this. And kindly see what is relies upon the inquiry officer's report in the criminal case. He has got no other material. Kindly see, my lord, the page 66. First, if your lordship would kindly come to page 49, my lord, there is no other witness. Peruse the report submitted by investigating officer, inspector of police, vigilance, anti-corruption, in which chemical reaction of solution is distinctly stated. Page 49. Now, my lord, the lordship is aware of the judgment of the Supreme Court in Khatri, my lord, where, my lord, when a police report would be relevant in a, my lord, proceeding under 226. Since 1981 to SCC 493. Now, if your lordship would kindly come to page 498, why I am saying so, my lord, there was no evidence. Please come to page 498. It bars the use of any statement made before a police officer in the course of an investigation under chapter 12, whether recorded in a police diary or otherwise, but by express terms of this section, this bar is applicable only when such statement is sought to be used at any inquiry or a trial in respect of an offence under investigation at the time when such statement was made. A statement made before the police officer in course of an investigation under chapter 12 is sought to be used in a proceeding other than an inquiry or trial, or even at an inquiry or trial, but in respect of an offence other than that which was under investigation at the time when such statement was made. The bar of section 162 is not retracted. This section has been enacted for the benefit of the accused, as pointed out by this court in Tahsildar Singh. It is indeed to protect the accused against user of statement of witness made before police during investigation at the trial, presumably on the assumption that said statements were not made under circumstances inspiring confidence. So, my lord, a statement made before the police, not to speak of a trial of that particular case, my lord, even otherwise also, it is not admissible. Now, please come to, my lord, the last para, line about 1, 5, 6, 7. Line about 7 from the bottom at page 498. The sentence starting with, but this protection.
Yes.
But this protection is unnecessary in any proceeding other than an inquiry or trial in respect of offence under investigation. And hence the bar created by this section is limited bar. This is important. It has no application, for example, in a civil proceeding or a proceeding under Article 32 or 26. And statement made before a police officer in course of investigation can be used as evidence in such proceeding, provided otherwise it is relevant under the Indian Evidence Act. That means, my lord, if under section 33 and 35 of the Evidence Act, I have the right of cross-examining those witnesses, then that can be used. So these are one-sided things, my lord. They have done some exercise by the investigating officer. So these are no material, my lord, to take action in an administrative law matter. It will be admissible only when it complies with the requirement envisaged by the Evidence Act. That is, then when Lord, supposing a witness is witness adduces some evidence, then I must be given opportunity to cross-examine him. If some document is introduced, then I must be given an opportunity to confront them. Then only it will be admissible evidence in a 226. Now, Lordship is deciding this matter under 226. Now, whether the police report constitutes a material to be taken as a material in a case to punish me, my humble submission is no. So, from whatever angle, my lord, we view at it, it's an overall, my lord, it's a case of absolute arbitrary exercise of power, disregard of the rules and procedure, my lord. For a moment, I am not saying that I am not guilty of the offense. If ultimately in the criminal case I am held guilty, in any case I will lose my job. But say, based on the charges, my lord, that I can be penalized and dismissed, that is something extraordinarily wrong. This cannot. I am entitled to my protection. I am entitled to my procedural safeguards, which has there is violation of Rule 9, no list of witness, no list of documents, no right of cross-examination. God knows, my lord, what was proved in that inquiry. At least reading the inquiry report, we do not find any finding. Taking an overall view in this matter, it's a fit case where Lordships will allow the petition interference.
For statement of witnesses, Manan, only I have got it a record. Accused is the driver of the blood petitioner, and who accused has admitted that 40,000 was given to him to keep him to safeguard to him by the petitioner. That statement is only there, and other statement, complaining statement is not there. Only this co-accused, Afizul Ali. Sir Afizul Ali hereby I am the co-accused in the police case number on the 24th of October 2018. So the intermediate Ahmed, not Motor Distur Motor Cycle had handled by me. Yes, itself. I had kept the sum of money in the case car. At the car. After about the hour of incident,
Who handed over the money?
That is the driver, his driver.
Who handed over money to the driver?
No. Oh yes, the petitioner received the money. Money after thereafter, he handed over to his driver.
From the statement, you tell us.
It is
What is stated there? The statement again. Read the statement, please.
I will. On the 24th of October 2018, Syed Intermuddin Ahmed, the petitioner, Latmondor Discord Saiful had handed over me a sum of 40,000 in case to keep safe. I had kept the sum of money in the car. After about 1 hour of this incident, I saw police arresting Syed Intermuddin Ahmed and taking him along. I stayed at the office premises, and after about the hour, and I got note to the police was charging for me as well. I then proceeded towards the anti-corruption office and handed over the money to the police. They had asked me to wash my hands when a pink color solution appeared. So the police then checked the serial number so currency notes and arrested me as well. I was then kept in jail for a period of 7 days, and thereafter I was released. It is the statement of the co-accused, the driver of the petitioner, who kept the ultimate money from the petitioner. Actually, first petitioner received the money, and petitioner to anti-corruption trap laying officers, they found his hand is right hand is when to wash it is pink color, and he also pocket also comes to pink. That is the fact. So in public proceeding, so far the appointment of second officer, second enquiry officer, it is not actually second officer, and he
my lord, my lord, what happened, my lord, this Vishwajit Soikia is appointed to complete the half done. The first is 47. 47 is just, my lord, Dharna Jyoti Patgiri was appointed as an inquiry officer, first time.
Submitted.
He submitted a report, but he did not complete all these things, my lord. Therefore, and he also claimed that some certain documents were not provided to him. Thereafter, this Vishwajit Soikia, the second inquiry officer, has submitted certain things, my lord, page 57. But to kindly see. 8/7/2024. The petitioner, the delinquent officer, complained that he was not furnishing documents in connection with DP. So that was not, at the first inquiry officer did not submit. That's why, with reference to the subject cited above, I would like to furnish here with the following documents as sought for, on the basis of which the departmental proceeding was drawn up against you. These are the 4 documents he sought for, that was submitted. Thereafter, he given reply. And thereafter, my lord, this inquiry report submitted by the Vishwajit Soikia, he only the report on the basis of documents and my lord, other report of the first inquiry officer that he has completed. That is complete. That's why last one in this regard it is mentioned that the inquiry officer, Dharna Jyoti Patgiri, SCS, Assam Metropolitan District, has already submitted the inquiry report on 31st of August 2023, when the delinquent officer was found guilty as charged. The copy of the inquiry officer was served upon the delinquent officer on 10/6/2024 in DP number. However, 18/6/2024, the delinquent officer has raised objection to the inquiry report. This is the objection. That's what that was beat up by the Vishwajit Soikia, the second inquiry officer. Actually, that second officer was appointed to complete the inquiry officer performance, the first inquiry officer performance complete. The appointment letter says, my lord, to complete. Page number page 61. Order. This is the order. He says, my lord, my lord, consequent upon transfer of former inquiry officer of GP level of 2000. Grown up in respect of soil intermediate Ahmed, then record assistant. The Vishwajit Soikia SCS Additional District Commissioner Kamruk Metropolitan is hereby appointed as inquiry officer for completion of the said departmental process. But with this, my lord, is not a fresh second officer, inquiry officer, but to completion of the said departmental proceeding, he is directed to conclude the departmental proceeding within 30 days. That is why, my lord, it cannot be deemed to be a fresh second inquiry officer appointment. It is officer due to on the already first inquiry officer transferred, and he could not complete and submit all these things, my lord. That's why, my lord, and could not meet up the complaint raised by the petitioner. That's why this officer, Vishwajit Soikia, is appointed as a appointing officer, the inquiry officer, to complete the said department. He has completed it 8 months. The report is there, my lord. Can you see? Report is page 63. In this report, my lord, from the Vishwajit Soikia inquiry officer, he did not take anything, my lord. The report of the first inquiry officer inviting a reference to the subject cited above. I have the honor to submit here with a report on the inquiries conducted by the undersigned as per section 97 of the rules 96. The charges framed against Ahmed Dispur on the basis of records presented to the undersigned. On the basis of records presented to the undersigned, that means the earlier inquiry reports and other documents. Charges framed against the Sir Interpreted Ahmed Dispur Latmandal, who was placed under suspension right 8/11/2015. Charge 1. Violation of section 13 of Prevention of Corruption Act 99 as amended, lack of integrity and honesty. As presented, Mohammed Interpreted Ahmed Latmandal, Sunapur Circle, has been caught red-handed while accepting bribe 40,000 from Sri Panchami's home. The DSPS case number 4.
Charge number 2, causing embarrassment to the government, tarnishing the image of the administration and affecting the reputation of the government. First, as reported, he was arrested on 24th October 2018 and was remanded for prudent effort. In this regard, it is mentioned that the inquiry officer, Dhanagiri Patgiri, Kamrup Metro, has already submitted inquiry report on 31st of 2022. The delinquent was found guilty as such. The copy of the inquiry report was served upon the delinquent official on 10/6/2024. And however, the 18/6/2024, the delinquent official has raised objection to inquiry report on the following ground. So to meet up all these things, this procedure has completed. These are the. But on 8/7/2024, by letter dated so and so, he was served once again with all the documents he claims on non-receipt, and he has submitted reply on 18 July 2024. However, he has not submitted any new evidence or witnesses to prove anything contrary to the report submitted by the alia inquiry officer. That's why, my lord, alia inquiry officer, whatever submitted, that was the remain, and he did not produce any new evidence or witnesses to prove anything contrary to the report submitted by the inquiry officer. Such deed has already been submitted by the inquiry officer, inquiry police officer, SCG PS the presenting officer in his report has also presented that the delinquent official would not produce any substantial evidence in favor of dismissal of charges in view of the above. After careful examination of documents presented, nothing contrary was found against the report by the letter 31/2023, and charges framed against the delinquent official is reconfirmed, and action may be initiated accordingly. That was the his only reports. The second officer, he completed it. He has given the finding. So, there is no procedure left in the part of that he was punished, he was proposed, and he replied, and thereafter, inquiry was
After
done.
submission of documents, he again furnished a reply.
Yes, he submitted. No, he did not submit anything. He received it, document, but he did not submit anything. What he will submit, He did not submit in the first inquiry report, inquiry proceedings. There is no evidence on behalf of him to deny this thing. So, 65 is a inquiry officer report with the final subject. I am to enclose you the report submitted by the inquiry officer in connection with the so, and any objection, explanation in this regard may be submitted to the undersigned in writing within 15 days. So he was given enough opportunity. He given the inquiry report to submit the his explanation, and thereafter this page 63 order passed by the the disciplinary authorities has gone through the records and also reports of the inquiry officers accordingly has passed this order, and there is no infirmity in this order. So further. But he has submitted reply, sorry, page 64 on 8/7/2024.
Subsequent reply.
Yes, subsequent, his documents,
Page number?
Page number 64. Paragraph
64.
Second, on 8/7/2024, he was served once again with all documents. He claims of non-receipt, and he has submitted reply on 18/7/2024. So he has submitted reply,
18/7.
18/7.
I'm sorry, it is there at page 53.
18/6.
But he
18/6.
he has not submitted anything.
18/6.
No, 18/7.
18/6.
18/7.
Where is 18/7?
Page 64. He submitted reply on 18/7.
No, but where is that reply?
reply is my lord to the correspondence.
Page 53 is the reply on 18.6.
86. So, my lord, my husband he was given enough possibility to defend his case, and disciplinary authority must have fairly conducted the disciplinary proceedings, and there is no lapse on that. All rules and regulation has been followed. That's why, my lord, his dismissal order is
No, first you help us to understand the sequence of documents. Page number 63, submission of the report,
Second report.
second report. There at page 64, they, on 8.7 he was furnished.
Yes.
All documents submitted with the there is another aspect. Submitted the documents. Is it by the subsequent
Officers.
officer? He submitted.
Yes.
He furnished the document.
He furnished the document.
So come to page 62. 24/7. How could he submit documents on 8/7 prior to his appointment?
He was appointed on 24/7.
Page 64, he says on 8/7 he has submitted.
Perhaps, my lord, that was by the earlier
No, it can't be on perhaps you're holding to the record. You
Record
tell us
is there.
from the record.
my lord, reply to the letter 8/7/2024. I have got it. Yes, sir. Inception, I beg to say that I have received a letter 8/7/2024. Sir, I have replied to your letter to 10/6/2024 by email and say may be taken as part of it. Regarding the document 1, WT message dated 25th of October 2018, received from the Superintendent of Police, Vigilance and Corruption, Assam, he said that at 24th October 2018 at around 7 p.m. Mohammed Interview Ahmed Nath Mandal of but he was caught red-handed while accepting bribe of 40,000 for issuance of the permission of complainant Timothy.
Mr. Sutia. Stated that served all these documents. The reply was submitted on 18/7. But the inquiry officer was appointed on 24/7.
Actually, my lord, earlier inquiry officer, during that period, I think that was when he raised his point. That some documents are not given to me.
No, what do the records say? The
The
records of the disciplinary proceeding reveal when the documents were, when the notices were issued. You have to take trouble to go to the record.
We have given it a break time record, my lord.
In the break time.
Yes, my lord. I have not,
Why have you accepted the records in the break time?
no, my lord, no, nothing. What to do, my lord? I will have to do. If had it been in my chamber, but in the night, my lord, I can go through it. Not in the break time, my lord.
Night
Short
he gets
period.
not additional
No, no, my lord.
additional string.
This is my lord, short time. I will have to within time, my lord, I have to time and within.
We'll give you the night, as many nights as you want.
That will be better, my lord. Because one thing is that there is no pagination in the record. That's why very difficult to. I will find out it, my lord. I will submit, my lord. I think that I will go through it, my lord. I will submit your inquiry.
I'll give a short reply after my learned friend.
ঠিক আছে। Be permitted is not there.
Similar.
Well,
Deep learning.
Obliged.
hearing from the revenue. The represents the revenue.
Sir Lordship, I'm appearing on behalf of Mr. H. Betala. He had some medical emergency, so he had to leave immediately for the private response.
Yes, ma'am. Joint commission from promotion from deputy commissioner to joint.
What do you say? What date take? The question is that there are 2-3 judgments of the court. Why this court should not be bound by it? That's the question. Both of them are having medical emergency. Father, my lord. Father was here in the morning. Was very much in the morning. Tell us when you want.
Next Tuesday, madam.
Okay, everything can be on Tuesday.
Next Thursday. Or any day subject to me.
So any day subject to me, today is a good day, tomorrow is also a good day. You tell me what date is good for you. Maybe not 19,
19, ma'am. Yes, ma'am.
19 May.
And the interim order may be continued, ma'am. And it may be shown as part heard, ma'am.
Mr. G. Bushra Bharat.
Interim order may be.
Interim order pass कर ली गई.
This matter next week. Can I date be fixed?
Come next week.
Actually, the date may fix.
What date? Come on, for meetings are complete. Oh, let it come for hearing.
The matter pending since last more than a year now. Apologies.